Okay, let's talk about a really specific Japanese tax rule that catches so many US businesses completely by surprise. We're talking about a massive 20% tax on payments you probably wouldn't even call royalties. But you're gonna wanna stick around because there is a powerful and totally legal way to get that tax rate all the way down to zero. So just imagine this for a second. You did it. You just landed a huge client in Japan. Maybe you're licensing your software or a patent, or heck, maybe you're just leasing them some specialized industrial equipment. The deal is done, the money should be rolling in. It feels like a huge win. But then, you look at that first payment, and you realize something is very, very wrong. And this number is the problem. Before a single cent even leaves Japan, the government there withholds 20.42% of your gross revenue. Yeah, that's a 20% tax plus a little 2.1% surtax on top. So on $1 million deal, that's over $200,000 that you just never see. It's gone. So what is happening here? Is this some kind of mistake? Did your client mess up the paperwork? Nope. This is the default setting. It all comes down to Japan's standard domestic tax law for anyone who's not a resident. Let's dig into how this actually works. You see, under Japanese law, any company in Japan that pays a non-resident like you for income that's considered sourced in Japan has to basically act as a tax collector. They are required by law to withhold that tax right at the source and send it straight to the government. It's how they make sure they get their tax revenue from foreign companies. Now, here's where it gets really tricky. Let's look at their definition of a royalty. You know, in most places, you think of a royalty as a payment for intellectual property, right? Well, under Japanese domestic law, the definition is incredibly broad, and this is where the trouble really starts. Okay, so patents, software, know-how, that all kind of makes sense. But look at that last one. Leases for machinery and equipment. I'm not kidding. If you lease a piece of industrial equipment to a Japanese company, the payments you get are classified as royalties, and that means they get hit with that full, painful 20.42% tax. So right about now, you're probably thinking, well, this is a disaster. But it's not, because every good story needs a hero, right? And in the world of international tax, the hero is almost always a tax treaty. In this case, it's the specific agreement between the United States and Japan. This is the key dynamic you have to understand. On one side, you have Japan's broad domestic law. That's the default rule for everyone. But on the other side, you have the US-Japan Tax Treaty, which acts like a special override. It gives you narrower, much more specific definitions, but, and this is important, it only applies if you're a qualified US resident. And here's the most crucial part. When the rules of that domestic law and the rules of the treaty clash, the treaty wins. Every single time. It has the legal power to completely change the outcome. Now, this isn't some shady loophole. It's an intentional system designed to make sure you're not getting taxed unfairly in two different countries. All right, so let's get to the good part. Let's see exactly how this treaty takes us from that painful 20+% tax rate down to a much, much happier number. This is where you see the real-world dollars and cents impact of knowing these rules. Here's the headline. This is the big payoff. For a qualified U.S. business, the treaty takes that awful 20.42% withholding tax on most types of royalties and drops it all the way down to zero. That is a massive difference, and it all comes down to one tiny but powerful detail. Let's go back to our equipment lease example for a second. Remember, under Japan's regular domestic law, that lease payment is a royalty, period, and it gets hit with the full withholding tax, no questions asked. Let's just see what that looks like with some actual numbers. Okay, so you're supposed to get $1 million. But under the default rule, your Japanese customer has to withhold over 200 grand and send it straight to the tax authorities. You're left with less than $800,000. That is a huge chunk of your revenue that's just gone before you ever get to touch it. And here is the magic trick. The tax treaty has its very own definition of royalty, and this is the absolute game changer. It specifically excludes payments for using industrial, commercial, or scientific equipment. The treaty basically says, nope, that's not a royalty. Instead, it gets treated as regular old business income. So what happens when you apply the treaty? that income gets reclassified as business profit. And as long as you don't have a physical office or what they call a permanent establishment in Japan, that profit isn't subject to Japanese tax at all. The withholding rate plummets to zero. And just like that, the entire $204,200 is right back in your pocket. You get your full $1 million. Now, this all sounds fantastic, right? But, and this is a big but, it is not automatic. You can't just call up your Japanese customer and tell them not to withhold the tax. There is a formal process you have to go through to prove that you are eligible for these amazing treaty benefits.
The burden of proof here is entirely on you, the U.S. business receiving the money. You have to proactively claim these benefits. You have to provide all the right documentation to the Japanese tax authorities, and you do that through your customer.
It really breaks down into 3 key steps. First, you have to prove you're a U.S. resident, and you do that by getting a special certificate from the IRS called Form 6166. Second, your Japanese customer has to submit an application for you. It's called Form 3 to their local tax office. And third, you have to meet a couple of anti-abuse conditions. That means you have to be the true beneficial owner, not just some middleman. And you have to satisfy something called the Limitation on Benefits Clause, which is there to make sure companies from other countries can't just use the treaty to get a better tax rate. So, after all of that, what's the one single thing you absolutely have to remember? What's the one big idea that could save your business a ton of money? Well, it's really summed up perfectly by this quote, pulled directly from Article 12 of the treaty itself. This is the legal foundation for everything we've talked about. It says that if you're a U.S. resident, your royalties from Japan can only be taxed in the U.S. Japan gives up its right to tax that income at the source. So the big takeaway is this. Definitions are everything. The difference between Japan's broad domestic definition of royalty and the treaty's very narrow, specific one is the entire ballgame. Knowing this distinction and then structuring your contracts and your compliance process around it can literally change your net income by over 20%. And so that leaves us with one final question for you to really think about. Go take a look at your own international deals. Are they structured with this kind of knowledge in mind? Or is there a 20% tax leak hiding in plain sight, all because of how a single word is defined?